I can't do anything with them. Even if I buy your argument as completely true, you're still suspended and were, on the date of this ticket, my ticket, the one I've got authority over, you were suspended by the Secretary of State. Whether or not that was a valid or invalid suspension, you were still suspended. So we've got 2 DWS files, correct?
Over another who's in board status, but I think we're here on this motion hearing.
Yeah, so one file's a money issue. The old one from December 2016, that's a drove while license suspended. The file shows you owe money.
Yeah.
Right, all right. So we'll talk about that one. All right, and then you filed a motion on the case from November of 2025, correct? All right, give me a minute to look at the paperwork. Okay, I did see Mr. Blade's motion. I did have a chance to see that, read that one already. So I'm going to read the people's response.
Right out of the gate, the judge shuts down the emotional angle and anchors everything to one cold fact: suspension status. It doesn't matter whether the defendant thinks it was fair. The Secretary of State listed him as suspended. That's the battlefield. 2 files, 2 timelines, but one controlling issue. The court isn't here to debate feelings. It's here to enforce records.
Okay, I've had a chance to review. So anything you want to add to your written brief?
Just knowing that there was no personal jurisdiction in the court back the authority to make a judgment or default judgment.
You're talking about the Monroe case?
Yeah.
Okay, go ahead.
They lack jurisdiction in order to make that case or make a judgment for.
Anything else?
I can't find them any reason to prove service and collective. I saw people service from Turbo.
Just to be clear for the record, we're still talking about the Monroe case?
Yeah.
Okay, go ahead. Right.
To ask for proof of service that were unable to provide.
Right.
They told me that it was for the sheriff. Well, we go to the sheriff's office to ask for the proof of service because that's their reason.
Right.
Because I didn't receive the notice to appear in court, so I had no idea that it was charged again.
Okay.
And going forward, I go to the sheriff's office. I ask for the proof of service from Sheriff's Secretary Bird. I'm not sure if that's the order of position or if she's at running the test. But she noticed that the ticket had the officer's name, which happened to be down currently the defendant. He come out and spoke. He said, I don't remember this ticket. I don't even believe I was, I don't even believe I was on that shift at this time. A few things that he mentioned to. So I wasn't prepared for this. I was studying everything supposed to be correct. When he spoke to me, I took what he said and I said, okay, maybe I can get him to fill out an affidavit.
Right.
The things he said, I'm not asking him for anything in my favor, just what you recall, all I wanted. He didn't respond in time. He mentioned that he would have no problem speaking to the court here for the last case. But I didn't receive that response to the court. But he went through my motion. The officer said he believes that I did have insurance, but I was pretty sure force. Having in the opinion of the court to be there, nothing. It's pretty charged.
Okay. Anything else?
Now, the defendant tries to crack the foundation. He claims improper service, no notice, even an officer who doesn't remember the ticket. It's a bold strategy: attack jurisdiction and unravel the suspension at its source. But the argument feels scattered. He's leaning on confusion and memory gaps, hoping that procedural smoke turns into reasonable doubt.
Anything to add to your written response that I just read?
Nothing, yeah, the court is well aware that this court doesn't have any jurisdiction over a no proof of insurance citation that was issued by Monroe County Sheriff's Department in 2005.
All right. Mr. Blade, I've got a question for you. Do you know whether or not the Michigan Secretary of State listed you as a valid driver on November 29, 2025? Okay. So if I told you the Secretary of State record showed you were suspended on the day that Officer Hayden stopped you, you would have no reason to take issue with that fact? If I told you that your driving record listed you as a suspended driver on November 29, 2025, you have no argument one way or the other whether or not that's the case. No, that's all right. I don't want an answer if you don't understand the question. If I told you your Secretary of State driving record showed you as a suspended driver on November 25th of 25, would you have any reason to deny that as factually correct? Okay. All right. So I'm going to deny your motion for two reasons. Number one, his actions are based on what the Secretary of State says, not what the Monroe County Sheriff's Office says. B, I don't have the authority to do what you're asking me to do, because if I understand the situation, your Monroe case has been completely adjudicated in Monroe. They've left that on your record. I don't have the authority to change that record.
That's not what my motion is asking. I'm only asking you to recognize the jurisdiction. That's all I'm asking.
I can't do anything with them. Even if I buy your argument as completely true, you're still suspended and were, on the date of this ticket, my ticket, the one I've got authority over, you were suspended by the Secretary of State. Whether or not that was a valid or invalid suspension, you were still suspended. So my ticket, the Huron Township ticket, is a perfectly valid ticket moving forward.
But the jury,
The judge pivots sharply. One question matters. Were you suspended on that date? The defendant can't clearly deny it. That hesitation seals the moment. The judge explains his authority is limited. Even if Monroe messed up, the suspension existed. Legally, that's enough. It's a clinical dismantling of the motion. Jurisdiction beats outrage every time.
Gather your thoughts. I'm not in any hurry. These kids want a show.
people judge engagement without prior notice can be deemed as a violation of the party's right to due process.
Absolutely. Absolutely. But not by me. I can't override the Monroe Court. Now, I can take all this into consideration when I sentence you on this file, but I can't set aside what happened in Monroe. Okay. Okay. Are you just seeking to mitigate your damages here? Are you just seeking to mitigate your damages in this court based on what happened in Monroe?
Monroe is the reason I'm here. So
Absolutely.
We can't separate the two because it's the Monroe charge that got me of driving without
Right.
care that got my life.
Right. I understand that.
I did patient. Which absolutely true. Would you like to see that?
No. I'll for today's argument, I'll take your word for it.
He actually had insurance,
Right.
but I didn't have an opportunity to defend, to show the court that I had insurance. So going to jail and then to prison right behind us, when I come home, I'm trying to get my life together.
Okay. Well, first of all, I can't speak from personal knowledge of Monroe, but every court I know of on a civil infraction, they don't send a notice out on the civil infraction. The ticket is your notice that you've got a problem you got to deal with.
But I didn't receive it. I went to jail that.
So they never handed you a ticket. Okay. Well, then you got a problem, but I can't fix it. I don't have the authority to fix it. If we have a trial on today's DWLS case as prosecutor, she's going to have to prove to me that on November 29, 2025, your driving privileges were suspended in the state of Michigan. And she's going to have to prove to me that you were driving a vehicle on that date in Huron Township. If she proves that to me, I'm finding you guilty of drove while license suspended, revoked, or denied. The fact that the Secretary of State shouldn't have suspended you does not change that at all. You were suspended. Whether or not Monroe screwed up or they didn't screw up, you were suspended.
The defendant frames it as a due process violation, saying he never got the ticket and ended up in jail without a chance to defend himself. It's emotional and personal. The judge doesn't dismiss the frustration, but he refuses to overstep. He narrows it back to trial elements: suspended status and driving. That's the lane. Everything else is noise.
So I'm denying your motion. Okay? I'm assuming we can have some pretrial conversation.
And you're,
Okay.
like, if one wishes to plead to be drove while license suspended, I will dismiss the two remaining.
And I don't even have the remaining charges, so are they already in default? Or did I just not get the files?
Your vehicle and another misdemeanor registration title among the two.
Oh, I'm sorry. I was looking for civil infraction. Okay. All right. Do you want to avail yourself of that offer? He will dismiss 2 misdemeanors if you plead to the drove while license suspended. So the misdemeanor unregistered vehicle and the plate or registration violation misdemeanor, right, those 2, would be dismissed if you plead to the drove while license suspended, revoked, or denied.
The
hallway is yours. Yeah, go take a minute. That's fine. Why? You no objection to another? We'll adjourn it.
With the motion denied, the energy shifts to strategy. The prosecutor puts a deal on the table. Plead to DWLS and the other misdemeanors disappear. It's pragmatic. The court gives space, no pressure theatrics. This is the system recalibrating. Less argument, more negotiation. Now it's about risk management, not righteous speeches.
Oh, I don't care. March 12th, give you enough time?
Yes.
Okay, so Heather will prepare a notice on that one. Now, as to the December 1, 2016 file, our records show that you owe $840. Are you in a position to make some kind of a payment plan on that?
I currently don't have any money.
All right, you're confused. You don't have any money today?
Yes.
All right, but you could commit to some regular payments and make them. How much, how often, when do you want to start?
But I don't make very much money.
I need you to make some kind of commitment today if you can. You don't have to start it today.
It shows that.
Okay. How much?
Even if it's just one number.
No, I'm not paying a clerk to process a dollar payment. But I got to get something going. How's this? When's the last time you worked? Where do you work? Walmart? Cormart. What do they do? Okay. Full-time job? Okay. Can you pay $50 a month? Start when? First Friday of March is the 6th. And that's 2 weeks out. Can you do that? $50 a month. We'll always take more, so if you want to pay extra. $50 a month, starting March 6th. Yes? Agreed? Okay. We're getting you notice on that other court date. Have a good day.
Yeah.
You're welcome. Officer Haydeck, always a pleasure. Be safe.
All right, guys, let's break this down. The courtroom drama cools off and reality walks in. $840 owed. No grand constitutional debate here, just money. The judge pushes for commitment, not excuses. A $50 monthly plan gets locked in. It's practical, almost anticlimactic. After all the legal fireworks, it ends with budgeting. Accountability wins the final word. Make sure to like the video, subscribe to the channel, and we'll see you in the next one.